Identify the preconditions prior to commencing arbitration. I have successfully argued cases where my opponents have commenced arbitration without complying with the preconditions. And this goes to the questions of, and these arguably can go to the question of jurisdiction. Now, if a precondition in the arbitration is not satisfied, arguably the constitution of arbitration, including the arbitral tribunal and the rendering of the award, may be set aside or challenged. What are the examples of some of the preconditions? Some of the common examples are mediation.
There are three topics on which expert evidence is typically required in international arbitration, and these are quantum, technical or scientific fields, and foreign law. Quantum experts are engaged to quantify the damages being sought or the loss suffered. Sometimes this will be in the form of a loss of profits calculation, and sometimes by way of a share or business valuation or through some alternative calculation method. Technical and scientific experts are used in a wide range of circumstances and very often in construction disputes. Other cases where there might be a need for a technical expert might be where there is a dispute as to the cause or failure of a large piece of machinery, or where there is a dispute as to whether a vessel was in a seaworthy condition when it became a casualty. Foreign law experts are relatively common in some jurisdictions' states' courts, where they can assist the domestic judge in understanding the foreign laws which parties have elected to apply to a contract. In arbitration, although the tribunal will often have been selected with the law of the contract in mind, it is not uncommon for the laws of other jurisdictions to become relevant.
Next important remedy is injunctions. There is no objection in principle to an arbitral tribunal granting relief by way of injunction if requested to do so either on an interim basis or as a final relief. An arbitral tribunal is not usually empowered to make effective orders against third parties, and if injunctive relief against third parties is required, it is generally quicker and more effective to seek it directly from a national court. Most sets of international and institutional rules make it clear that an arbitration clause is not to be taken as excluding the jurisdiction of the relevant national court to make orders for interim measures of protection.